Our seats, so I'm going to do that in the interest of making this discussion a little more informal. In the Merrill Lynch Enron case, the prosecutors that include now Chief White House Counsel Catherine Rumler and General Counsel Deputy Director of the FBI Andrew Weissman actually yellow highlighted crucial statements by witnesses as Brady evidence before the trial, and then withheld selected yellow highlighted passages of Brady material from the presumably accurate summaries they were supposed to have produced pursuant to the court's order. Unlike the Stevens case, we could not even get a hearing on our motion for new trial in that case. And the Fifth Circuit's decision finds that they plainly suppressed evidence favorable to the defense, which meets the test of the ethical rules as a violation of the ethical rules, but held that it wasn't material, despite the fact that the prosecutors had told the jury 16 times in closing argument alone the exact opposite of the crucial evidence they withheld. And the Fifth Circuit admitted also that the evidence would have impeached two of the key witnesses in the case. So how that comes out as not material, only that panel of the Fifth Circuit can really understand, I think. Certainly no defense lawyer would agree with that. So I think the question for purposes of our ethical panel is, what are we going to do in terms of bar associations and our rules of ethics? Are we going to hold prosecutors accountable? Courts want to punt to the bar associations, and bar associations and Department of Justice want to punt back to the courts and just say, oh, well, because no court has found that there's a Brady violation, we're not going to look into this. Well, if we're going to protect individual liberties, including those of every person in this room, we're going to have to take a stronger look at a standard to hold prosecutors to and enforcement of that standard. What happened to these Merrill Lynch defendants could happen to anybody. They served a year in prison on charges that did not even constitute a federal crime under the indictment as it was charged, because we couldn't get them bail pending appeal. They were all fine, upstanding citizens, one of whom Judge Werlein, who sentenced him, described as the most impressive person that had ever appeared in his courtroom and was just doing his job. But he went to prison for a year, denied bail pending appeal on an honest services charge that wouldn't stand up at all. So, what are we going to do about these prosecutors? Are we going to apply the rules of ethics? Should the states start some sort of commission on a state-by-state basis, like Texas has a court of inquiry that's looking into the case that Professor Rotunda mentioned, and I think it may be the only state that has that process. But the state bar associations need to take this a lot more seriously than they're taking it now. Bill Hodes stepped up to the plate and filed grievances with me against each of the prosecutors in our case, and so far Texas bounced it like a rubber ball and said the complaint didn't even state an offense, and the D.C. Circuit initially rejected the one against Ms. Rumler, but is reconsidering it now, and the others we haven't heard from.
All right, I think our next is going to be Mr. Weinstein, who will tell us whether all prosecutors are now conducting misconduct or they did it also while he was a prosecutor. All right, let's start. So let's start the interactive round here by asking both Ron and Sidney this question. So what should we do? But to do that, we should talk about where we are already. So as Ken was saying, the Deputy Attorney General Ogden issued a memorandum after the Stevens case saying that the policy of the Justice Department would be that disclosure must be made of any information that is inconsistent with any element of the crime charged, regardless of whether the prosecutor believes it's material or not. Sidney, more laws or just more zealous enforcement or more sensitive judges or what?
I think it's going to take a combination of things. I think district judges need what Judge Sullivan called a healthy skepticism for the mantra of prosecutors that we know our Brady obligation and we've complied with it. That was replete in our case. It was replete in the Stevens case. It's typical in every courtroom across the country that I know of. And if the judge really knows the prosecutor and their local assistant U.S. attorneys, sometimes you know that that person's word is rock solid. but other times that's not true, and we need to be willing to look behind the curtain more often than judges do. In terms of the ethical rules themselves, bar associations really do need to step up to the plate here and do more investigation. There are not that many Brady claims filed in front of bar associations, and particularly not by practicing lawyers. They might be filed by disgruntled defendants, but I think the bar should take very seriously any complaint filed by another respected member of the bar alleging any sort of Brady violation, particularly when there is not only evidence of it, but there is yellow highlighted evidence of it that's directly contradicted by what the prosecutors repeatedly told the jury. I agree with Ken that there are cases, of course, I was a prosecutor for 10 years in 3 different districts, where you need to protect a witness or you need to protect homeland security issues, as he is well aware. Those cases are more rare than they are the rule, and that can certainly be accommodated under an open file discovery policy that should be the presumption as opposed to the exception. There are districts where an open file discovery policy works, and people use the exceptions as they need to, but depending on the case and the judge.
So would you change Rule 16 to turn it into open files?
I would like to, yes.
So there's 2 arguments I've heard against open files. One is open files becomes the needle in the haystack without any winnowing. In fact, this was the argument in the Oklahoma bombing case, that government turned over so many statements in so many DVDs and CDs that the defense couldn't find the part that they thought was important. And second, that if you leave out the exculpatory and impeaching material, but just look at open files as a whole, you eliminate the possibility of being able to contradict a witness who is otherwise lying by some inconsistency either in the facts or prior statements or something else. And that since cross-examination is supposed to be the world's greatest engine for discovering the truth, you eliminate that possibility. Do you think either of these are worthy considerations, Jim, since you started talking about open? Sidney, was everybody like Pericles when you were a prosecutor? Are they now all corrupt?
No, but I do think it's gotten worse, and I think it's especially gotten worse in the more high-profile business cases. I think there's been an over-criminalization of business conduct and too great a willingness on the part of prosecutors who want to make a name for themselves to overreach either in charging decisions, evidentiary decisions, Brady decisions, whatever. It's just, it's gone too far. I know Department of Justice has made some effort to correct that, but I don't think the Ogden policy goes far enough by any means. It really doesn't have any teeth to it. It can be modified on a district-by-district basis, and the Department of Justice, frankly, if Judge Sullivan had not thrown the fit he threw and was prepared to dismiss the indictment himself, wouldn't have done the investigation that they did on those allegations. Our case alone proves that. So there's just a whole lot more that needs to be done about it.
All right, if anybody needs a rebuttal, we'll have a chance, and then we'll go to Sidney, you want a last word?
Yes, I think as a matter of law, the Brady standard needs to be reevaluated and materiality disentangled from the prosecutor's initial decision whether to produce anything. It is too easy for an unscrupulous prosecutor or somebody who just wants to win a little too much to say, oh, well, that's not material, when in fact a prosecutor is absolutely no judge whatsoever of what's material to the defense before a trial. And materiality was really, I think, intended to substitute for a harmless error analysis in deciding whether a criminal conviction should be reversed. And the Supreme Court's questions to counsel in Smith versus Kane imply that at least 4 of the justices thought that also.
All right, well, it was actually quite clear, though, that in both Strickler and in Kyle, that they were not, that was the argument in the case, that they should have that rule, that exculpatory should be the Brady violation, harmless error should be what happens if there is a Brady violation, and the court rejected it. It is quite possible, though, that the court will come a different way, and one of the defense counsel in this table may bring that case, and there will be the opportunity. There was, by the way, cert was just denied this week in a
And Shaken.
Shaken, which was a Hyde Amendment case. As I mentioned, Hyde is the case about getting attorney's fees for a vexatious, frivolous, and bad faith prosecution. Judge Pryor for the 11th Circuit said that has to be objectively bad faith. The cert petition sought to make it subjective, and the Supreme Court on Tuesday denied. So at least that issue is not going to go any further. But the Brady issue could, at any day, wind up before the court. Do we have
your own inculpatory witnesses? I think among other things, the Fifth Amendment's active production doctrine would cover that. That's kind of a Brahmin defense notion, but I throw it out there.
Next question?
Yes, I'm Bill Hodes. I worked with Sidney Powell on the appellate aspects of that, the last piece of the Enron case. And I was, for 20 years, a law professor specializing in legal ethics. And I want to make one comment looking backwards, and then a comment and a question as forward as to how we deal with these issues. The backward-looking question is to remind us all that, as the last exchange showed, as we sit now, there's a disconnect between the constitutional rule, I also taught con law, between the constitutional rule for what it takes to overturn a conviction or habeas corpus or whatever it is, and the ethics rule which is imposed upon prosecutors after it is later discovered that there was what I call a real deal Brady violation, not a mere clerical error, but a deliberate, knowing attempt to hurt the defense by knowingly violating. Now, I believe that that it won't be long before the materiality requirement will be taken out of the initial part of Brady, because it just simply is unworkable to put, for all the reasons that Ken gave and Sidney both, it's unworkable for the prosecutor in the midst of a case to be able to figure out what is going to be exculpatory, because they don't know what the defense case is. And even the most honest prosecutors have the tunnel vision that was discussed. So the rule is going to be somewhat similar to what the Justice Department now says rule is going to be, which is basically we turn over everything. I'm not sure of the difference between open file and if we see it and it's exculpatory, including for purposes of impeachment, which is part of the Brady rule, then we just turn it over. And then if it later turns out that something wasn't turned over, and which, by the way, we have no idea how many cases there are when that was asked of Sidney and Ron, we don't hear about the cases. I don't know how many there are. My guess is that there are, in fact, quite few, that most prosecutors do it just about right, but we just don't know how many. But then, then later, when you decide the remedy, you decide how important it was it material, was it harmless error, or whatever. But looking backwards to the cases, in the old era when there still was this disconnect, it really does seem to me to be imperative to say that if there are rules which have been adopted not by the ABA, but as Ron just said, by the Supreme Court of each of the states, and then made binding on federal prosecutors and others through the McDade Act or the McDade Amendment, then it has to be treated seriously. And the real difference between the Brady rule as a constitutional rule and the disciplinary rule in all of the states is that there is no materiality requirement. And therefore, if you have a deliberate case in which a prosecutor is known to have, or is later proved, to have deliberately taken, has not given away, has not turned over clearly exculpatory evidence, whether it would have been material or not, that has to be treated seriously. Now, that blends to the future. As I think Sidney mentioned in passing, we filed charges, disciplinary charges, because we thought we had something like 20 exhibits that we filed in New York, DC, Texas, and then with OPR as well, on the 4 prosecutors involved in that case, showing the actual grand jury transcripts and other information that the prosecutors had, that they had highlighted, and that were not turned over. In Texas, we were shot down immediately. In DC, we were shot down, but now they're reconsidering it. And going forward, though, what I want to say is we just learned today that the other case from Texas that Ron mentioned about a 25-year-old prosecution, that case is going forward. There was a case in Louisiana in which a prosecutor who admitted on his deathbed to another prosecutor that he had hidden evidence. He died, but the other prosecutor was brought up on charges for not disclosing it about the other one. That's for those who know what the rule book says, that's a Rule 8.3, a mandatory report situation. In DC, where we are still in the process, they are actively bringing charges against a former U.S. attorney here in D.C. In a case in which the whole argument was it material or not material? And so my question is, or comment and also question for reaction is, going forward, if we, taking Ken's point, which I absolutely do, that you must limit it to what I call the real deal cases, that it should be a situation in which really the only way to stop this is, however large the problem is to have high profile, not just reprimands, but serious consequences. And I'll end just with one little anecdote. In the legal ethics bar, I'm for some reason, most are heavily liberal. I'm known as the somewhat more conservative end of it. And when the Duke rape case came down and the prosecutor there was rightfully disbarred, I mean, he had done not just Brady violations, but he had lied to the court and he had fabricated evidence and so on. When he was disbarred, on our chat group, a lot of people said, oh, big deal. They were rich white guys and they had lawyers, and so if this had been somebody else, then nobody even would have cared about it. They would have pled guilty and that would be the end of it. And my response is